Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. And tonight's lecture is going to be on Chapter 3, and we will be discussing expanding the concept of crime, looking at this really funny word that's out there called corpus delicti, and you've probably heard it before, but you probably don't know what it means. And then we'll look at some additional principles of criminality as well. So let's just go ahead and jump right into tonight's lecture. So by way of introduction, on March 30th, 1992, David Smith's double-wide mobile home in Orangeburg County, South Carolina, suffered damage from a fire. Now, investigators determined that the fire had started in the kitchen and was the result of cooking oil ignited after being heated in a deep fryer for at least an hour. And although no accelerant was discovered, investigators found evidence that the house had been sterilized, if you will, prior to the fire. Outside of the trailer, a trash can filled with children's toys was found. In a pump house adjacent to the trailer, personal items were discovered in 2 suitcases, one bearing an identification tag with David Smith's name on it. Now, the items included photo albums, love notes, jewelry, and things like that. And moreover, the back door, which was a sliding glass door, was open about 3 inches. One investigator suggested that the door had been left open to provide an oxygen supply to facilitate the burning of the fire. Now, Smith and 2 associates were later arrested and charged with arson. Before trial, however, defense counsel moved that the trial court conduct an evidentiary hearing out of the presence of the jury for the purposes of determining whether sufficient evidence of the corpus delicti existed to proceed to trial. Excuse me, and we're going to learn what that word means. And counsel argued that the government must establish the incendiary nature of the fire before it can get into the issue of statements and admission. Now, the trial court agreed and conducted a hearing at which 2 arson investigators testified, and at the conclusion of the hearing, the trial court held, in order for the state to establish corpus delicti in this case, it must provide evidence that the burning was by a willful act and not a result of natural or accidental causes. There has been no testimony whatsoever to suggest that this fire was in fact the result of a willful act, that any criminal agency, person if you will, was involved whatsoever, and that these defendants had any connection with the fire that resulted. And there was more, but they add at the end here, there was no testimony that would even support the theory of circumstantial evidence, wherein if employed, it would have to exclude every other reasonable hypothesis except point towards the guilt of these defendants. The trial court then dismissed the arson charges against all 3 defendants. Now, this is another interesting concept here, this corpus delicti. And these paragraphs, if you will, that I just read to you were taken from the 1996 South Carolina appellate case State versus Williams. And they highlight the importance of this thing called corpus delicti in the judicial process and give some insight into the nature of the concept itself. So, what is this thing, these words called corpus delicti? Well, the term corpus delicti literally means body of crime. And the term is often confused with the statutory elements of a crime, which we're going to talk about later, or taken literally sometimes to mean the actual body of a murder victim or some other physical results of criminal activity. The concept actually means something quite different. And one way to understand the concept of corpus delicti is to realize that a person cannot be tried for a crime unless it can be first shown that the offense occurred. You can't try someone for murder if you don't have a dead person or somebody that was killed. Does it kind of make sense? In other words, to establish the corpus delicti of a crime, the state has to demonstrate that a criminal law has been violated and that somebody violated it. So it kind of makes sense when you really understand it. So kind of a little bit of a rehash here. The best way to understand this corpus delicti thing is to understand that a person can't be tried for a crime unless you can show that the offense actually occurred. So again, in other words, to establish the corpus delicti of a crime, the state has to demonstrate that a criminal law has been violated and that somebody violated it. Now, there are only two components of the corpus delicti of a crime. One, that a certain result has been produced, and two, that a person is criminally responsible for that. So, as one court said, corpus delicti consists of a showing of, one, the occurrence of a specific kind of injury, and two, someone's criminal act as the cause of that injury. So I'm hoping that kind of breaks it down. And if you look on this particular slide here, I've given you a little bit of information that talk about corpus delicti and when it kind of comes into play. So an example under corpus delicti, evidence offered to prove the corpus delicti in a trial for larceny or theft is insufficient when the evidence fails to prove that the property has been stolen from another, or when property found in the accused possession cannot be identified as being stolen. So basically, you may think it's stolen, but if you can't show that it's stolen, you haven't proven the corpus delicti of that particular offense. Does that kind of make sense? So, corpus delicti must generally be established beyond a reasonable doubt. And along with that, the identity of the suspect is not an element of the corpus delicti of an offense. So, and finally, the fact that a crime has occurred can be established without having any sense of who committed it. So you may have a murder victim at a scene, so you know that there's a crime that's happened, and you may not know who did it. But again, you're only trying to establish those two things that we talked about at the beginning, that a certain result has been produced and that a person is criminally responsible for that particular result. So in Another case, real quick, in State versus Kendall, and this is back in 1924, it was said in a prosecution for murder, proof of the corpus delicti does not necessarily carry with it the identity of the slain, meaning the victim, nor the slayer, meaning the suspect. The essential elements of corpus delicti are establishing the death and the fact the death was caused by a criminal agency, which would be a person. Nothing more. So again, talking about this corpus delicti, other things will come into play as well, like confessions and what have you, and we'll talk a little bit more about that. So here's an interesting case study that we're not going to spend a lot of time on, but this is the Michelle Wallace murder case. Now, this individual was missing for quite some time. Foul play was suspected. They ended up identifying a person that they believe Miss Wallace gave a ride to. I'm trying not to give away the whole story. And for the longest time, they found evidence, again, that they believed there was some type of foul play, but they really couldn't find any harm. Basically, she was a missing person for quite some time. And finally, they were able to find the harm part, meaning that they found her remains, which proved the second part of that corpus delicti. So if somebody's missing for a while, I guess the thought here is that you can't prove that the person has been murdered just because they're missing. Because what would happen if you actually prosecuted somebody for, let's say, murder because they're missing and you believe this person did it, and then 10 years later they show up? So a very interesting situation, but I would highly recommend that you watch that video because I think it'll add some context to our conversation on corpus delicti. So confessions, they present an especially thorny area, if you will, when dealing with the corpus delicti of a crime, because corpus delicti holds that a criminal conviction cannot be based solely on the confession or admission of an accused. So, and you have to really kind of think about that. So again, generally speaking, the corpus delicti rule holds that a criminal conviction cannot be based solely on the confession or admission of the accused. As one court explained, it is a settled principle of law that a mere extrajudicial confession, uncorroborated by other facts, is insufficient to show the corpus delicti and cannot support a conviction. A person may, for example, confess to a crime, but if there is no independent evidence showing that such crime has ever taken place, the individual making the confession can't be prosecuted. So if a person confesses to murder, but suppose the murder victim was found alive and in good health later on. So you can see the problem of demonstrating the corpus delicti of a crime is more difficult when a person confesses, especially in this kind of situation, and a victim or a victim's remains can't be found, like in the case here. So this particular Michelle Wallace case, her remains were never found for quite some time. I believe it was 9 or 10 years, and otherwise she was just missing. There were a couple of circumstantial pieces of evidence that linked the suspect to her, but not enough because they couldn't show harm. They couldn't show that the actual homicide or harm had occurred. So I'm hoping that kind of helps explain the whole thing. So you can see the issues when we're talking about confessions. And again, imagine if a person confessed to a murder and that the person was tried, convicted, and sentenced only to have the victim return alive later on. Now, This is one reason why most states will not permit a confession to stand alone by itself as the basis of a criminal charge without some other type of independent or corroborating evidence. And it's important that you have that. Now, by definition, the rule, just so I can read it to you for corpus delicti, the body or essence of a criminal offense that proves that the alleged crime has been committed, but not who committed the crime. In practice, a principle of law that says that out-of-court confessions unsupported by other facts is insufficient to support a criminal conviction. And that's the corpus delicti rule. Now, that doesn't mean you can't arrest the person because you have some circumstantial evidence, but if you can't prove the corpus delicti, okay, you are not going to be able to prove that the person committed the crime. The rule is going to stand in the way of that criminal conviction. And another interesting case when we talk about confessions, this one's a little bit longer, but the case of Colonel Russell Williams, who was a high-ranking officer in the Canadian military, and turns out that he was a burglar, a sexual assault rapist, and a murderer. So watch that case, and I'm not going to tip my hat on that one too much. I want you to take a look at that one and see what you think. So a determination of the corpus delicti of a crime is also important. We know that, and it will generally be prosecuted in the location where the crime was committed, where the corpus delicti of the particular crime exists. Now, federal courts and a few state courts have abandoned the requirement of establishing corpus delicti of a crime because doing so is not always possible. So some attempted crimes, some high technology crimes, conspiracies, and crimes such as, let's say, income tax evasion, make the corpus delicti requirement difficult, if not impossible, to meet. So some states have kind of recognized that. And some scholars argue that there are 4 additional principles necessary to describe the essence of the legal concept of a crime besides actus reus, mens rea, and concurrence. And we've learned about those in the other chapters. And these 4 additional principles of criminality are what they call causation, a resulting harm, the principle of legality, and necessary attendant circumstances. So let's talk a little bit about these 4 additional principles of criminality, and the distinction of these will become clearer as we go through all of these. Now, causation refers to a relationship between the mens rea act and resulting harm. Whereas some statutes criminalize only conduct, others subsume the notion of concurrence under causation and specify that a causal relationship is a necessary element of a given crime. And they require that the offender cause a particular result before criminal liability can be incurred. So again, this refers to the relationship between the mens rea, the act, and resulting harm. And again, some statutes criminalize only conduct, others include, if you will, the notion of concurrence under causation, and basically specify that there needs to be a causal relationship and that's a necessary element for that particular crime. So, for example, the Texas Penal Code defines homicide as a person commits criminal homicide if he intentionally, knowingly, recklessly, or with criminal negligence causes the death of an individual. If there is no death of a human being caused by another person, the statute does not apply. So again, they require that the offender cause a particular result before criminal liability can be incurred. So here's a question. Does a person cause the death of another if he or she fires a gun at someone intending to kill the person and misses, but the person drops dead from fright? Think about that one a little bit as we continue on and talk a little bit more about these principles of criminality. So when discussing a specific ultimate harm, such as death, it is necessary to recognize the difference between causation in fact and probable cause. And these are a couple of definitions that we'll go over. Causation in fact is an actual link between an actor's conduct and result, and proximate cause is the primary or moving cause that plays a substantial part in bringing about injury or damage. Now, it may be the first cause that sets in motion a string of events whose ultimate outcome is reasonably foreseeable. So we're still under causation in fact, again, a link between an actor's conduct and result, and proximate cause, I just gave you the definition of that. Now, there are differences between causation in fact and proximate cause. If there is an actual link between the actor's conduct and the resulting harm, causation in fact exists. Now, you could kind of think about that as dominoes, if you will, setting things in motion. Factual causality can be determined through an interesting test called the sine qua non test, which holds in effect that without this, that would be not. And it's also referred to as the but-for rule. So, because it means that some injury would not have happened but for the conduct of the accused. So in our earlier example, the bystander would not have been shot but for the actions of the shooter. Similarly, he would not have been shot but for the fact that someone had chosen to build a wall out of, say, reinforced concrete, which caused the bullet fired by the shooter to ricochet. Even when factual cause can be demonstrated, however, it might not provide the basis for criminal prosecution, because the government must then prove that it is also legally recognized, or also a legally recognized cause. So again, here's an example of what we've kind of been talking about, but a little bit clearer. So if a woman poisons her husband's dinner, intending to kill him, but he stays late at the office and she puts the meal in the refrigerator, she may be held liable if the boarder in the house gets up in the middle of the night, eats the meal, and dies. In this case, the actions of the woman who intended to cause the death of her husband becomes the proximate cause of the death of the boarder. Does that make sense? Proximate cause, remember the definition, the primary or moving cause that plays a substantial part in bringing about injury or damage. So that example kind of gets there. So proximate cause exists in this example for two reasons. One, the woman set in motion a chain of events with potentially deadly consequences. And two, the boarder's consumption of the food in the refrigerator was a reasonably foreseeable event, and his death was therefore a foreseeable consequence of the woman's actions putting the food in the refrigerator. So when factual cause can be shown, however, it might not provide the basis for a criminal prosecution because the government must then prove that it is also a legally recognized cause. Proof of factual cause may be necessary for a conviction, but it alone is not sufficient for a conviction to result. Proximate cause holds individuals criminally liable for causing harm when it can be shown that the harm caused was reasonable and foreseeable. So still under the guise here of additional principles of criminality, the U.S. Supreme Court observed that proximate cause requires some direct relation between the injury asserted and the injurious conduct alleged. So if, for example, one person assaults another and chases him out of a building and through a driving rainstorm, the assault cannot be said to be the proximate cause of the victim's death if he's struck by lightning and killed. So kind of a corny example, but trying to kind of get my point across. So in an attempt to clarify the issue of causation, the American Law Institute suggests the use of the term legal cause rather than proximate cause in order to emphasize the notion of a legally recognizable cause and to preclude any assumption that such a cause must be close in time and space to the result it produces. So that was the first one in our list of four. If you remember, we were looking at the four different principles of criminality. So now we're going to move on to the second one. So the first one was causation, and now we're going to move on to resulting harm. So the need for some identifiable harm as an actual or potential consequence of culpable activity is often cited as a general feature of crime. If an action held no potential to cause harm, it would make little sense to pass a law prohibiting it, right? Personal crimes such as murder and rape cause specific harm to nameable people, whereas other offenses such as attempts may have harm as their goal but fail to achieve it. So still other crimes such as those against the environment cause a more general and diffuse, if you will, kind of harm, the impact of which might be fully felt only in later generations. So by definition, the need for some identifiable harm as an actual or potential consequences of culpable activity is often cited as a general feature of crime. If an action held no potential cause to harm, then it would make, again, little sense to make a law for it. Social order offense, a type of criminal law violation in which parties to the crime willfully participate and in which the element of harm seems remote. And these are also called sometimes victimless crimes. And social harm can be caused by their conduct. When a particular result is specified by law as a necessary element of a given crime, a successful prosecution requires both a concurrence of mens rea and the act, as well as concurrence of mens rea and the resulting harm. Even if the harm that results from the criminal activity is different in degree from the intended harm, the concurrence requirement is still necessary. And then finally, the principle of legality. This principle holds that behavior cannot be criminal if no law exists that both defines it as illegal and prescribes a punishment for it. Now remember, in California, you have to have those. California laws is statutory, it's written law. And in the writing of the law, there needs to be the definition of whatever it is that's illegal, and there needs to be a punishment. So the need for a specified punishment is definitely part of the principle of legality. So let me try to give you an example here. It's all right to drink beer in most places today if you are of drinking age, because there's no statute on the books prohibiting it. Now, during Prohibition, of course, the situation was a little bit different. So another one, larceny, for example, or theft, would not be a crime if the law simply said it's illegal to steal. Punishment must be specified by law so that the person is found guilty of violating the law. Sanctions can be lawfully imposed. So that, I mean, it kind of makes sense. And then what about this other funny term here called ex post facto? Now, the ancient principle of legality included the notion that a law cannot be created tomorrow that will hold a person legally responsible for something that he or she does today. These are called ex post facto. And ex post facto is a Latin term that literally means after the deed. An ex post facto law is one that makes an action done before the passing of the law, and one that was legal when it was done, criminal, and punishes such action, and then 2, aggravates a crime or makes it more serious than it was when it was committed. 3, inflicts greater punishment than existent law did at the time the crime was committed. Or 4, alters the legal rule of evidence and requires less or different testimony than the law required at the time of the offense in order to convict the offender. So you can see the seriousness of an ex post facto. So again, kind of in review, an ex post facto law inflicts a greater punishment than existing law did at the time the crime was committed. It alters the legal rules of evidence, and requires less or different testimony than the law required at the time of the offense in order to convict the offender. And clear examples of a violation of ex post facto are statutes that declare an act criminal after the act occurs, and those that increase the penalty for a crime after the act occurs. So another quick principle of legality is what we call double jeopardy. And this is something that we can look at in the Fifth Amendment if you have time to read it, and I would suggest that you do. Similar to the ex post facto principle, the Fifth Amendment to the U.S. Constitution states that no person be subject for the same offense to be twice put in jeopardy of life or limb. Now, through this double jeopardy provision, individuals may not be tried a second time for the same offense, or punished a second time for the same offense. Now, generally, this thing we call jeopardy attaches when the first witness is sworn in during a jury trial. A guilty plea has been accepted by the trial court, or the first witness is sworn in during a bench trial, which is a bench trial is a trial without a jury, where the judge actually makes the decision. So generally, double jeopardy attaches again when the first witness is sworn in for a jury trial, a guilty plea has been accepted by the trial court, or the first witness has been sworn in. Now, double jeopardy is prohibited by the Fifth Amendment to the U.S. Constitution. A legislative decision to increase the punishment of a crime after it has been committed cannot be applied retroactively, and the prohibition of being tried twice is limited to criminal prosecutions. And then finally, another principle of legality would be something that we call void for vagueness. So another aspect of due process which refers to a statute defining a crime that is so unclear that a reasonable person of at least average intelligence could not determine what the law purports to command or prohibit, meaning like what does it really mean? So this is interesting when it comes down to a couple of different laws that are there, and the example that I have up there is loitering. This is a law that's been on the books in several different states. However, because it's not defined very well, it was extremely vague. And it's very difficult to prove, because what if people are just kind of hanging out at a spot, talking or whatever, but they don't appear to have any lawful business where they're at. And you can see how the distinction there makes it very difficult to be able to prove that type of a crime. So another example could be the case I'm going to talk to you about now. In 1999, in Chicago versus Morales, the U.S. Supreme Court held that a city ordinance that prohibited criminal street gang members from loitering in public places was unconstitutionally vague and an arbitrary restriction on personal liberty. The court found that because the ordinance fails to give the ordinary citizen adequate notice of what is forbidden and what is permitted, it is impermissibly vague. The term loiter, said the court, may have a common and accepted meaning, but the ordinance's definition of that term, to remain in any one place with no apparent purpose, really doesn't have a meaning. So you can see the vagueness as it relates to the principle of loitering. So again, statutes are void when vague because their enforcement would require after the fact judicial interpretations of what the law means. An activity pretty much similar or akin to an ex post facto rule creation. And then another term, necessary attendant circumstances. Statutes defining crimes may specify that additional elements be present for a conviction to be obtained. Attendant circumstances refers to the facts surrounding an event and includes such things as time and place. Sometimes attendant circumstances increase the degree or level of seriousness of an offense. Circumstances surrounding a crime can also be classified as aggravating or mitigating and may, by law, be used to lessen or increase the penalty that can be imposed on a convicted offender. Aggravating and mitigating circumstances are not elements to an offense, so let's not get those messed up a little bit. So I know that was very quick. And again, we just kind of touched on a lot of the different subjects, but again, the focus was on the corpus delicti and on those four additional principles that we spoke of. Again, just to kind of sum everything up, don't forget to look at the summary at the end of the chapter, and also don't forget to look at the definition or the terms that are listed in your book, but they're also on your Canvas page. And with that being said, that will be the end of chapter 3, our lecture on chapter 3. Until next time.